Okay, so thanks for being here today with us, Mike. Excited to talk about all of the exciting action happening in the regulatory space for crypto.
Absolutely.
So there's a lot between the new SEC approach, all these task forces, the new regulatory legislation in Congress. So where do you want to start and dive in?
Yeah, I mean, there's so much happening. We've been talking about this for a couple days. I sent you my thoughts this morning, and already since this morning, there have been additional updates, additional changes. The biggest changes are happening on the regulatory front, right? You have actual shifts, definitive shifts at the SEC, the CFTC, the CFPB, and then regulators that you may not have heard of, like the OCC, the FDIC, FinCEN, OFAC, the alphabet soup that sort of determines what the regulatory posture is towards emerging industries. And you now have new regulators who have been named to these positions who are, I would say aggressively, but really like definitively pro-crypto. Paul Atkins at the SEC, he was an advisor to the Digital Chamber. Brian Quintez, who was former A16Z crypto head of global policy. Jonathan Gould at the OCC. He was part of the team that helped charter crypto banks during Trump 1. And you have, honestly, even more people who have an affinity, a tie, an understanding for the space. So there's a tremendous amount of opportunity with the regulatory environment changing pretty dramatically. You have a Congress, the 119th Congress, that's controlled by Republicans, the House and the Senate, but by pretty slim margins, a couple seats in the Senate and basically one seat in the House. You have, it's so tight that Trump's nominee for UN ambassador, Elise Stefanik, has been held from being confirmed to be UN ambassador because they need her vote in the House. So it's that tight. But the good news is that there's an emerging bipartisan consensus around clear rules of the road, that regulation by enforcement failed, that Congress honestly failed in not helping to clarify where things stand. Because ultimately, you know, like, you can blame Gensler, and you should, because he was terrible, but had Congress stepped in at any point during that era, it would have stopped him in his tracks, and they didn't. And so there's a real momentum around stablecoin legislation, market structure, and so there's real opportunity to actually get, for the first time, meaningful crypto legislation passed in Congress. And then, you know, don't forget about the courts, although we may be able to forget about the courts because the SEC keeps dropping cases. So some of the stuff that I would have thought might be litigated, and you might get a refresh of Howey and what that means. It literally may be moot in the federal courts, but there are still cases pending, so that's something to watch as well.
Yeah, those are all great points. What do you think that crypto founders and builders can expect, you know, more specifically from the new SEC administration? Like, what kind of practical things do we think are going to come first?
It's an important question. Obviously, the biggest shifts that we've seen, the most immediate shifts, are the change from the posture of regulation by enforcement, litigation, suing everybody that is a actor in the United States trying to build in this space, which was the posture of Gensler's SEC. And you're seeing what would have been unprecedented, which is before the new commissioner of the SEC has even been confirmed, before Paul Atkins has had his hearing in Congress, acting chair Mark Ayeda and the commission are dropping cases. They're dropping the case with prejudice, which is a legal term, but means they cannot refile it. They're dropping the case against Coinbase. That was, you know, $50 million on Coinbase's part, tens of millions of dollars from taxpayer funds to investigate and sue Coinbase for trying to comply and register and come up with a framework that works in the United States. Today, while I was flying here, the SEC dropped their investigation into Uniswap. Again, another good actor building in New York City, building in the United States, trying to comply, got a Wells notice that they were an unregistered broker-dealer and certain other violations. The SEC closed investigations into Robinhood, into OpenSea. They got a 60-day stay jointly filed with Binance. So this is as clear a page-turning moment as you can find in, U.S. government. It's really the kind of thing that my partners at Manatt, who are SEC or securities lawyers who don't necessarily understand crypto super well, but understand the SEC, are just shocked because they've never seen this before, because the SEC doesn't typically drop cases that are pending from a previous administration. And so I think that Gensler's actions were so outside the realm of reasonable, and the trust was so broken, and all of that led to these kinds of updates. And so that's the first thing. But you're also going to start seeing some proactive, positive developments with Commissioner Peirce's crypto task force. She was named to lead that project by acting chair Oyeda. She is obviously an OG of the space. She has multiple well-thought-out proposals on how to regulate crypto in an innovation-friendly, consumer-protective way. She has policies on safe harbor, on exemptive relief, on token classification, on custody, broker-dealers, like all of these things that the industry has been begging for clarity on, she has been working on. And the task force is publicly releasing who they're meeting with, and it's pretty much a who's who of who you would expect and who you would want them to be meeting with. And they're talking about, no action letters on airdrops and token classification and safe harbor and all of these ways to create paths for compliant token sales, issuances, and the like in the United States, which is very exciting.
Yeah, lots of exciting stuff going on, and I think we all are taking a collective, sigh of relief that this, regulation by enforcement era is coming to an end. But switching gears a little bit, what are some common pitfalls that founders should still remain more wary of, and what's some advice that you have on things that they should still avoid in order to protect themselves from risk?
Yeah, so I'm a crypto lawyer, or as a friend of mine says, I'm a crypto lawyer, but I'm not your crypto lawyer. So this is general advice, but it's actually really important because I think there's so many exciting and good things happening in the space, and the boot is off the neck for the first time in 3-4 years. I really longer than that, because whatever your thoughts on the current administration, the Trump 1 administration was hostile to crypto. Bitcoin is scam, filed the Ripple lawsuit, tried to put a last-minute midnight rule on self-hosted wallets, like a lot of antagonistic stuff towards crypto. So there hasn't really ever been a political administration that was pro-crypto, and so this is new. And so the exuberance is high, but we want to shift that towards positive, productive exuberance rather than irrational exuberance. And I think it's important to remember that the securities laws have not gone anywhere. The 33 Act, the 40 Act, these things still exist. They were written a long time ago. They can still be used by plaintiffs' lawyers to sue you. That is happening right now with meme coins and DAOs and other crypto projects where plaintiffs' law firms are suing under the securities laws, often using the legal arguments that Gensler's SEC made, but now in a private lawsuit capacity. That's still quite damaging to companies and can be bad, especially if the facts are compelling in those cases. Additionally, state regulators, state financial enforcement, state attorneys general, and the federal government still very much cares about fraud, about misrepresentation, about misleading marketing, about public sales of public things where people get rugged. They don't like that. And if you're communicating publicly, if you're marketing publicly, if you're tweeting, that's going to be the front page of the complaint, the lawsuit, the civil action, the state action, whatever. And so it's really important to remember that, because I think people get a little bit lost in the happy sauce now that things are moving in a much more productive direction at the federal level.
Yeah, I'd like to talk a little bit more about that because social media is oftentimes the first thing that'll pique a regulator's interest, and also private plaintiffs, lawyers, et cetera. And so I think it's important to be really cautious with your public, marketing statements. Do you have any do's and don'ts or recent examples of ways that this has gone wrong?
Yes. So I have a lot of experience dealing with state and federal regulators and law enforcement and investigators, and I can tell you that all of those people, the regulators, law enforcement, they are on crypto Twitter. They are reading articles. They are following this stuff, and they are using that as sort of a predicate to launch investigations to figure out where they think things are going wrong, where someone has misled, where someone is tweeting, buy this, we're really excited about it, it's going to the moon, and then people lose a bunch of money. They are literally reading that stuff and then going after it. And then once they have a predicate to launch an investigation, they can get internal documents and there's a subpoena, and it's a very, the investigation is often the punishment. It's expensive, it is invasive, it's really difficult, it's distracting, it's all of these things that you want to avoid. And so I have seen in multiple instances, the Hawk2a meme coin being the most recent. The Twitter activity there is the basis for multiple lawsuits that have been filed, as well as state and federal investigations that are ongoing. In all the cases from 2022, 2023, Terraform Labs, FTX, Genesis, Gemini, like any of these places where regulators or private plaintiffs sued, the tweets were the crux of a lot of these lawsuits. What people were saying is true, what was actually true. Oh, well, this ambiguous statement means this. No, it doesn't. And if anyone could take a sort of antagonistic view that you were trying to get money in based on your statements on Twitter to pump up a project or some sort of investment, like that is a very easy case for regulators to bring, for private plaintiffs to bring. It's not a securities law thing. It's much more of like a fraud angle, and that will always be an easier story for a regulator, for a private plaintiff, for anyone trying to like sue you into oblivion to make.
Yeah, and the fraud aspect doesn't apply just to securities. It applies to commodities as well. So regardless of, crypto not being a security,
right? It's great that tokens that are clearly not securities aren't going to be classified as securities, and you won't be sued for registration violations. But fraud is fraud, and my biggest piece of advice is don't do fraud, because if you don't, you will be in a much better position to take advantage of the environment shifting in a very positive direction for builders and companies and platforms and investors who want to do stuff the right way.
Yeah, so I guess just because the president launched a meme coin doesn't mean that everyone else should too.
Right. I mean, I've had clients who call and say, well, I can do this, right? Trump did it. And I will say, oh, so are you the president of the United States or a neighboring country? And clients are like, what do you mean? I'm like, he's the president. It's not, that's a different set of rules. Like, the securities laws still exist, consumer protection laws exist, anti-fraud statutes still exist. Don't do it. It's fun to be on Twitter. It's fun to message and bull post and all of these things. But I have literally seen in 10, 15, 20 different lawsuits, the first page of the complaint is a screenshot of someone's tweet. So assume whatever you're tweeting will be page one of a lawsuit against you. If you feel good about it, great, tweet it out. But if it's questionable or flat out false, just don't do it. It's a recipe for disaster.
Yeah, so consult your lawyers before you tweet.
Definitely.
Especially like during all hours of the night. They love that.
I love waking up to proofing Twitter, proofing X messages. Yeah, it's great.
Great. Well, I don't know if there's anything else that you want to talk about that we haven't already shared. Otherwise, I thought maybe we could open it up for questions. If anyone has any questions for Mike, not legal advice, but general advice about the law.
Hey, so thanks for this. Question. So with the changing environment in the U.S., do you see more foundations looking to kind of establish operations in the U.S. instead of going like the Cayman route?
This is a common conversation that I've had with many clients, some of whom may even be in the room. And I think that it's important to recognize that we don't yet know what the compliant path is, right? We don't know what Commissioner Purse's safe harbor proposal 2.0, 3.0, some hybrid will look like. We don't know exactly what that looks like. So to me, the Cayman approach, battle-tested, tax-neutral, useful for foreign investors, is still quite valuable in and of itself, regardless of the improvements. And I think the way I have been advising clients, and again, not legal advice, consult your lawyers, hit me up if you want to talk about it. But the way I've been advising clients is that I think that you move forward, but with an adaptable and flexible approach. The Cayman entity will be valuable. It will be useful. The main thing, honestly, that you can't change is tax law, right? Like, unless there's some sort of tax forgiveness where there's a goal of bringing, offshore crypto assets onshore for a tax holiday, you're not taxed on it, and then you're taxed going forward, maybe. But that hasn't happened. That would require legislation. And so long as the tax piece remains a big part of it, and I think it will, I think you will always have use for a Cayman Foundation or a foreign entity. But I think that there will be a much more adaptable approach, and I was just talking to someone where I was saying, I think that where we get is some sort of grafted U.S. entity, maybe that's the Wyoming Duna, maybe it's a different type of entity, along with the Cayman Foundation together, and it's less completely fixated on avoiding, securities law registration violations because there's a compliant path, but it's more about bridging the gap between tax, foreign access, foreign investors, and the U.S. environment and the U.S. path, whatever that may be.
Yes, Peter.
What are the top 3 mistakes and pitfalls that you see founders make during their entrepreneurial journey of starting a crypto company?
Great question. Crypto founders are really focused on the tech, on building, and that's what they should be focused on. That's what they're best at, that's what they know how to do, and that's what's going to matter for bringing users on. But that doesn't mean to ignore small, unsexy stuff that may actually be super important. This is like having proper documentation for your business, for your IP, for your employees, for all of that stuff. That's super protective to you, because if you're a big success and you don't have that stuff, it's going to be a real problem down the road. Similarly, something that's super boring, super unsexy, terms of service. Terms of service, the stuff you click through and don't read a single word of? That stuff is incredibly important for crypto projects, because as the risk shifts from absurd federal lawsuits based on trying to crush the industry into plaintiff risk, state regulators, consumer protection violations, all of that stuff, terms of service and what users and consumers are waiving and agreeing to when they use your website, your service, your protocol, your testnet is going to become incredibly, incredibly important. If you waive, there's case law on this where certain types and the way you frame the terms of service on a website versus on a phone or on an app, if you do it the same way on both, it will apply for one and would be unenforceable on the other. So imagine you have terms of service that waives class action lawsuits, waives damages, waives limits on liability, and that's null and void. And now you're wide open because you didn't think or care to spend a little bit of time and money up front on doing that the right way. So that's like a pretty big example I've been honestly harping on a lot recently, because I think the risk profile of that is at its peak right now. But that kind of stuff is really important, and often, again, it feels less sexy and cool and interesting and important to the business, but it actually is. So don't ignore the stuff that may seem background, and let your team handle it, right? That doesn't mean a founder needs to be spending all their time worrying about terms of service, like let your lawyers worry about it, and they will protect you.
I guess one last question. One piece of advice for all aspiring entrepreneurs in crypto about how they should approach the coming 4 years with the new administration and ever-changing regulatory landscape.
I like that question. It's almost a setup because I've been saying this to people myself, even when they don't ask me the question, which is we have a generational opportunity as an industry right now. It is like I said before, it's the first time where you have genuinely pro-crypto regulators, a pro-crypto political system, executive branch, Congress, states, and courts, where even Obama and Biden nominated judges are saying the SEC went too far. This doesn't make sense. Like all three branches are aligned, and this is a golden opportunity. And so my piece of advice of the next 4 years is build real stuff, do real work, solve real problems, like try to prove the point of what we've all been fighting for the last 4, 5, 6, 7 years, which is like, this is a real technology. This has a ton of potential. This can solve real problems. There's real use cases. This can help consumers. This can help investors. This can, go far beyond anything that we can even imagine right now. So that's my hope, and that's my advice as well. It's like, use this time wisely, because the meme coin casino nature of the industry will always be there, but that's a distraction. And if we only focus on that, then stuff will blow up, and then the political winds will change, and our current allies will become our enemies, and this golden opportunity will be squandered. So I really hope that everyone focuses on that and we don't miss this window.
Great. Thanks, Mike.
Thanks,
That's all
everybody.
the time that we have, so I'll hand it back over to Joseph.